Hi, my name is Kyusung Lee, head attorney of Osung Partners Law Firm. Many of our law firm's clients have come to seek assistance with dismissal of employee in Korea, especially those companies incorporated through foreign direct investment from overseas find it extremely difficult to deal with labor-related issues due to strict stipulation dictated by the Korean labor laws with respect to dismissal, the requirements regarding dismissal procedures, and hope it is useful for many foreign investors. Complying with dismissal procedures is important. To dismiss a worker, the employer should give at least a 30-day notice or 30 days worth of ordinary wages. This is called dismissal notice rule, and if employer fails to comply with this rule, the dismissal itself will turn out unjust dismissal and may be nullified if presented to Labor Relations Committee. There is an exception to this dismissal notice rule, however. This does not apply to a worker who has worked for less than 3 months or where continuation of the business is impossible due to natural disasters, incidents, or other unavoidable circumstances, or where the worker has intentionally caused serious damage to the business or property loss, which falls under the reasons prescribed by the MOEL's ordinance. Written notice of dismissal. Employer must provide to employee in writing dismissal notice which should be communicated to the worker along with the reason for dismissal and the timing. Failure to abide by what is prescribed in terms of the procedures makes the dismissal invalid. Thus, employer may have to reimburse all the salary during which takes place during the period of dispute regarding the dismissal. Let me tell you the related articles in the Labor Standard Acts of Korea. Article 26, Advance Notice of Dismissal. When an employer intends to dismiss an employee, including dismissal for management reasons, he or she shall give the employee a notice of dismissal at least 30 days in advance of such dismissal. And if the employer fails to give such advance notice, he or she shall pay such employee a 30 days ordinary wage at the least, provided that where any of the following is applicable, this shall not apply. First, where the period during which the employee has worked continuously is less than 3 months. Second, where continuation of the business is impossible due to natural disasters, incidents, or other unavoidable circumstances. Third, where the employee has intentionally caused serious damage to the business or property loss, which falls under the reasons prescribed by the ordinance of the Ministry of Employment and Labor. Article 27, Written Notice of Grounds, etc. for dismissal. When an employer intends to dismiss an employee, he or she shall notify the employee in writing of grounds and timing for the dismissal. The dismissal of an employee shall become effective only upon a written notice pursuant paragraph 1, where an employer has given an employee an advance notice of dismissal under Article 26 in writing, stating grounds and timing for dismissal. The employer shall be deemed to have given notification under paragraph 1. The timing at which a dismissal should be executed is also important. At certain timings, dismissal should not be executed according to the laws. These timing includes period during which a worker takes time off due to any injury or sickness arising out of duty and for 30 days thereafter. Period during which a female worker takes time off due to maternity leave and for 30 days thereafter. All in all, dealing with dismissal itself and complying with the required procedures turn out very tricky. Therefore, I would recommend consulting with experts and acquire proper legal assistance. Thank you.